Yes, thank you guys so much for joining me today. So I just want to let everyone know who's listening. Bert and Tony were they helped some fellow members of our group, the Arizona Neighborhood Alliance, that were being sued by their neighbor for tortious interference, and the members were attorneys. And I believe they had you guys consulted with them during the hearing. This whole case. But that case
Right.
they ended up winning in the Circuit Court of Appeals. And so at least we have some kind of precedence going forward. But that's how I got to know about you guys and reached out to you. And so the questions that are going to be asked today are from our supporters. They're the most pressing questions that we've been getting for years. So if you guys are okay, let's go ahead and get started.
Absolutely.
Okay, perfect. So we'll start with kind of an easy one. Since it's not illegal to have a yard sign, short-term managers or owners or property managers have been sending cease and desist letters to a lot of people as their way to kind of counteract that or threaten the neighbors, the residents in the neighborhood. Can you let us know, is it okay for residents to ignore cease and desist letters?
Great question. First of all, each cease and desist letter is probably going to be a little different. I don't know what, depends on the signs. If your signs are small, they're well within your own property, they don't contain anything, vulgar or racist or otherwise, objectionable along those lines. Are you in the wrong for having a sign on your yard? Probably not. That's the case that you referred to a minute ago. Our clients had signs in their yard and they were fine with, the court was fine with that, said it was a valid exercise of their First Amendment right to free speech. If you do get a cease and desist letter that you may be able to ignore it without any problem. A lot of times that is probably what you should do, just ignore it. And they've had their say, they vented, they sent you the letter, that felt good to them, and now you just ignore it and go along with their business. They may or may not ever do anything more. On the other hand, if you get a cease and desist letter, that may mean that they're about to take a next step, bring a lawsuit. So I guess, can you safely ignore a cease and desist letter? You may not be liable, but you may be dealing with a lawsuit. Anybody can file a lawsuit. And sure, even if they don't have a good claim, it can be a distraction, an unwanted, expense.
Mm-hmm.
So.
But you can kind of, is it almost, would you say, kind of like a gamble? You can ignore it, or that if you get something, some legal response, something else in the mail later, or something is sent to you certified mail that from these people, all right, well, maybe I should have taken it seriously, or.
Well, I guess best practices, if you get a cease and desist letter, consult with a lawyer. Okay. Get some legal advice. Your lawyer may say, don't worry about it. This is what they're going to do. This was a cheap way to try to threaten you, intimidate you. Don't take the bait. Just keep doing what you're doing. You're on solid ground. I doubt they'll bring a lawsuit. If they do, we'll deal with it. Or your lawyer might say, you know what, the things they're complaining about in this cease and desist letter, these are problems for you. I didn't realize your sign was over the property line or contained these words. That's really not something that you're allowed to say. So, each case might be a little different. I can't really say you can always ignore a cease and desist letter.
Sure. But I suppose when we're talking about the signs and how far people can go or whatever, is there a red line where residents, if they have a problem, short-term rental next to them or across the street or whatever, or somewhere adjacent to them, and there are issues between them and the property owner and property manager, how far can they go? Are they allowed to, we've had questions, can you have cameras pointing at that property? You know, it's on your property, the camera is. Can it point into their property? Is that illegal? Like how far can you go with some of, you know, some ways to protect yourself?
Great question. I mean, I can tell you, for example, the signs that our clients had in their yards. These are, you know, the signs that our clients had, these are on the safe side of the line, right? These are signs that have already been actually used in real life, and they were not liable for those signs. Their signs said, Mr. Investor, please come talk with us. By the way, for context, our clients learned that one of their neighbors was about to sell her property to a short-term rental investment company. The buyer was going to turn the place into a hotel.
Okay.
And so these signs were really aimed at the prospective buyer, and really they were trying to break up the deal. They were trying to persuade the buyer not to buy this property for use as an STR. The sign said, Mr. Investor, please come talk with us. Another sign said, angry neighbors not good for business. Another sign said, our piece is not for sale. Those are the three that, I think there was one more. It said, no Airbnb house at 1717 street address, whatever. So those are all on the safe side of the line, presumably.
Okay.
Those have actually been used, and the clients were found, you know, not liable for tortious interference.
Okay.
I'll chime in there. One bright line is the truth. Is what you're saying in a sign or in any kind of speech true? If it's not, it could be actionable by somebody who's saying, hey, that's a lie, that's meant to defame, that's meant to misrepresent. So the truth is always a bright line. Certainly any suggestion of violence would also be another bright line. I mean, people can get very impassioned when it comes to your neighborhood and protecting your neighborhood. And sometimes we use words in ways that might be construed differently than the way we intended them, and maybe even in a violent way. That's a bright line that I would be very cautious about.
Okay.
Any type of speech or sign.
Well, and as far as cameras go, like I know that there are some people, you know, we have a lot of cul-de-sacs, you know, in Arizona, and there's been some talk that, you know, the front yard is one thing, the backyard is more of a private space, but the way some cul-de-sacs are, and depending on the age of the neighborhood, walls might not be as high. And so if someone's camera from their front yard is aimed at the backyard of a short-term rental and it sees everything that's happening in the backyard, they're not liable, correct? I mean, the camera is on their property. I mean, it's facing that backyard, but is that a problem?
My own experience with cameras, I mean, if that were a problem, I think, you know, Ring cameras and other types of security cameras would have a lot of problems, because we put those up all over nowadays, right? And they're intended to safeguard our own properties, right? But they're always seeing other people's properties as well. But there's also the right of privacy that you've got to weigh against that, you know, your own right to put cameras on your property to safeguard your property. And I think if a camera is intended to, you know, violate someone else's privacy, that could be an issue. It's not something we've come across in our practice.
Okay.
But I'd be cautious about that. I'd be cautious about, you know, looking into someone's yard if that was the purpose of the camera, and especially if it was a private area and a backyard. That's something I would be cautious about myself.
Sure. Okay. All right. Tony, did you have anything else, or is?
Bert's answer was probably more satisfying than mine. Mine was going to be basically, it depends. You know, it just like Bert said. I mean, it's picture the argument that the other party is going to make. I mean, if they're going to say, look, if they're going to be able to tell the judge, look, the camera was placed on the top of the roof line of my, you know, it's aimed directly into my property. It doesn't even capture any of his own property. It just captures mine. Let's look at the footage. Okay, that's going to be a problem. And that's the one end of the spectrum. The far other end of the spectrum is, you know, the Ring doorbell camera that just looks at your front porch.
Mm-hmm.
That's pretty much all it captures. And then there's everything in between. And where that line is, you know, I don't know if we can give you a bright line. If you have a concern, I would say consult with legal counsel probably to make sure, if you really want to be safe. But yeah, it's going to be courts, the judge, and a jury is going to look at that as a reasonable person.
Okay. Okay. Well, and I suppose going along with that, as far as the cameras and stuff, from the short-term rental owner's perspective, they consider that harassment. So we've had a few people that have been served with, you know, I don't want to say harassment charges, but
Injunctions against harassment,
yes,
probably.
exactly.
Yeah.
And so somebody had a question about what recourse does an individual resident have against harassment charges brought by short-term owner or property manager if they're an LLC? Is that something, or is it technically the people behind the LLC? Like, how does that work? Is there?
Well, if you have been served with an injunction against harassment, all that means is that, you know, let's say you own a property and your next door neighbor is an STR owner, and the STR owner has gone out and gotten an injunction against harassment. You've been served. All that means is that the STR owner has gone to the court and made allegations that, if true, the court said, yeah, I think that rises to the level of harassment. Now, once you get served with that injunction, you have, I believe it's 1 year, anytime during the next year, you can request a hearing where you basically say, hold on, I want my chance to tell my side of the story, because some of the things that are being alleged, that's not accurate. That's not how it happened. And so you'll have a hearing, you'll go to the court, and we've done these, we've done several of these where we've, successfully defended our clients against an injunction against harassment. And the remedy is not always super satisfying. The injunction gets dissolved, and you may or may not recover your attorney's fees. It's expensive to fight, but I don't know if that answers your question, but you do have a remedy if you get served with an injunction against harassment. You can beat it.
Sure.
You can go to court.
You can go to court and all that. And I mean, I know there have been some people that have been served, and Susan in the chat brings it up about someone who was served. They got a $50,000 demand letter for reporting to the police, for nuisance problems at that short-term rental. I mean, obviously you'd want to fight that, but I mean, have you come across anything like that as far as harassment charges based on calling the police because of nuisance problems?
Not that specific example, no. I don't think I've defended anyone where the injunction was based on my client having called the police, but your instinct, I think, Kate, is right. I mean, if you have called the police in good faith because you're concerned about, a possible crime or at least a violation of an ordinance or something else that's happening that's not good on the STR, if you've called the police in good faith because you're concerned, that's not harassment. Now, it could rise to the level of harassment. You can imagine a scenario where a neighbor calls the police every day, and it's over things that a reasonable person probably wouldn't complain about. Sure. And then in that, you can imagine a scenario where there would be a basis for calling that harassment.
Sure. Okay. All right.
I'll chime in on that just a bit. I mean, in the world of what somebody can ask a court to do, getting an injunction against harassment is probably one of the easiest things to get a judge to rule on. You walk in any court, any jurisdiction, and same day you get to talk to the judge, kind of tell them what's happened in a really layman's type of way. They're designed to protect against domestic violence and other more serious forms of harassment, and so they're easy to get for that reason. And so you'll get people like these short-term rental owners probably who are looking for any tool they can to intimidate somebody into quieting down, right? Hey, don't get in the way of this short-term rental is the idea. And that's a fantastic tool if they can come up with a valid basis for harassment. That does take direct contact. You can't, harass someone, through calling the police. That's not going to work. Well, if it does, you can defend that pretty easily. But it's surprising, most things that you ask a court to do can take months, years even, for any type of ruling or decision. But you walk into court and same day you can get an injunction against harassment if you have the grounds, or if they allege the grounds. It's ex parte proceeding, so it's just the plaintiff there with the judge telling their side of events, maybe making things up in a lot of cases. And if there's enough of a basis there, the court will grant it, and then that person can serve the defendant shortly thereafter. And all of a sudden, what? This has been decided? I didn't even know about it. It's surprising, and because usually when you get a court involved, there's a lot of due process involved, a lot of protections, and there are in the case of an injunction against harassment as well. But your burden as a defendant, if an injunction has been issued by the court, is to then try to quash it. You can get a hearing within days. That's pretty quick too, a return hearing. In the meantime, you are obligated under that injunction, and you shouldn't disregard it. But you can quash that if it was an invalid basis, if the facts that were alleged are untrue, and so forth. So that is probably the most likely judicial remedy that you'll probably have to deal with, because to go a different route to try to get a Superior Court, type of traditional injunction takes thousands of dollars and lots of time for a plaintiff to do. I don't know that these short-term rental owners are going to go through that process very often. Maybe they'll threaten it, maybe they'll send a demand letter or a cease and desist letter, but they're not going to get anywhere with the strength of a court order for a very long time. And so this idea of an injunction against harassment is very good to be aware of, to understand. You could field that quite easily. And the good news is there's an easy way to defend against them if they have been issued. But that's probably the most likely court proceeding that you'll encounter.
Right. And so I assume on the flip side, then we've had a lot of people who have been asking about, what the remedy is from their side against the short-term rentals next to them. So there are a lot of people, who are having, they have the golf thing, the chip things, the putting greens. And so golf balls are constantly coming into their yard. And then those visitors jump over the walls to come onto their property in order to retrieve, the golf balls. Or like the woman on here who was talking about, the guests the guests that harass residents, yell at them over the fence, if cops are called or for whatever reason. There have been some that have been threatened with assault or have been assaulted by guests. Is that the same type as an order of harassment, the same type of thing you would use against the property owner? Or at that point, especially if you have a home that's a repeat offender, people are always coming over onto your property. They're different people. There are always different people that are visiting the home. But if people are, consistently, coming onto your property, is the order of or the injunction of harassment, is that the best case scenario, or would it be to, some sort of civil suit?
It would be, in my opinion, you'd have an uphill battle trying to get an injunction against harassment against the property owner, because if you're the STR owner and you let guests come stay and they leave your property and go other places next door, maybe 3 houses down, maybe to the mall, whatever, and they do bad things, it's pretty tough, I would think, to hold that STR owner responsible. Now, this specific example that I think Dominique has asked about, the STR guest has harassed you. I guess what I would do in that scenario, you have a remedy against the harasser, the person that comes over and it trespasses on your property. Let's say you have a sign up, no trespassing, a STR guest hops the fence to retrieve a golf ball. Yeah, you have a remedy, I guess, against that person that hopped into your yard. It's not going to be very satisfying. You could sue them for trespass. I don't know what the damages would be. You'd spend a lot more than you'd ever recover in a lawsuit like that. But I think what I would do is start to create a record. I mean, I would send the landlord or the STR owner, or whatever you want to call that person, letters and letting them know on this date, this happened on this day, and start documenting those things. And, I can see an argument at some point where you say to the court, look, it was not the STR owner personally that hopped my wall and gathered the golf ball, or came to my house late at night and tried to break in a drunken state. But the STR owner knew about it, because I've told the STR owner repeatedly, here's the 8, 10, 20 letters that I've sent to the STR owner informing them of these things, and they've done nothing to stop it. And so really they ought to be, they ought to bear some responsibility for that. I think you might be able to make an argument along those lines. I still think it would be an uphill battle. I think a better argument would be, a civil suit against the STR owner for nuisance or something like that.
Okay. All right.
I'd say your most immediate remedy in that type of situation is to call the police. I mean,
Yeah.
if there's a danger, if there's a trespass, especially if it's posted no trespassing, that really takes you to a different level of trespass, where you're not just limited to civil trespass charges. If it's posted no trespassing with the statute there and everything, that becomes criminal trespass if they flaunt that. And that becomes an easier report to the law enforcement folks, and they're more serious about enforcing that. That becomes a higher priority for them if it's a criminal trespass situation. So,
well, yeah, I mean, I guess I would assume that the argument that some of the residents would make is that then the cops, they would call the police, and by the time the police got there, no one, that person has gone back to the short-term rental. They haven't seen anything. Is it one of those things where, if you do have obviously camera footage of someone coming over, someone trying to get into your home at 3 a.m. drunk or whatever, trying to break in, maybe the cops would take it seriously. But if they come out to the house, that is then on record, correct? Whether or not they found that somebody violated. I mean, don't they have to be there in order to say that
the police don't necessarily have to witness it themselves? I mean, most crimes occur
correct
outside of the,
right.
So the police don't have to see it themselves. I would say your instinct is right. I mean, if you can capture it on video, so much the better.
Mhm.
Because otherwise, the policeman comes out and they'll take a statement from the complainant,
Mhm.
and you'll say, wow, the neighbors next door hopped my fence. They were over here, 5 minutes before you arrived. They arrived.
Mhm.
Or they left my property and went back to theirs. And the policeman might go next door and interview them. I don't know, but it might be your word against their word. I think the police are more likely to believe the person complaining. But if you have some sort of evidence, some sort of record, it's a lot better.
Yeah, and I suppose, like, to Dominique's thing about her comment about having called them 100 times and they don't do anything, that's probably something that we should take to the city and deal with the police probably directly and find out what that problem, what's going on there. But as far as visitors of the STR coming onto property, if they are drunk, if they jump a wall to get a golf ball or whatever, and they say they slip and fall, hit their head, fall into the pool, whatever, they are injured on your property, who is responsible at that point?
I think you'd have so I guess take it to the next level, assuming that drunken visitor, while on your property, assume they, after being injured, they filed a lawsuit against you, which, people have done crazier things, but that seems like sort of a bold, crazy move to me to, after trespassing on someone's property in a drunken state and slipping and falling and hurting yourself, then to sue them. But maybe they would do that. If they did, I think you'd have a pretty good defense. They were there as a trespasser, unless there was some sort of obvious dangerous condition that you had in your yard. It was foreseeable that person would come there and be injured. I don't see why. I think that's a loser of a lawsuit if they were to file a lawsuit like that.
Okay. And for the trespassing that you guys were talking about before, is it imperative that people have the no trespassing with the statute sign in their front yard in order for that to be taken seriously by the police? Do you have
I
to
wouldn't say it's required, but if it's posted no trespassing, it does bring an element of notice into it that puts it into a criminal trespass type of analysis.
Okay.
So hard to predict what law enforcement's going to do on any given day, any given officer. But if they do it right, and if it has been posted no trespassing, that's going to become a more serious type of report. Typically, they'll come out and do a police report. Sometimes they'll go and knock on, the next door neighbor's door, say, hey, we understand there's a problem. They'll try to keep the peace, and maybe even make an arrest if it was egregious enough. But having that no trespassing posted sign on there, it does put you in at least a possibility of action by law enforcement.
Okay. All right. And then kind of moving on to another issue with this is that a lot of the cities are doing some of the new ordinances that they're passing they include a requirement that a new short-term rental owner needs to alert all adjacent neighbors that they're going to be in operation. So there's been a lot of confusion about when if a resident goes to sell their home, because they've received that notification, does that have to be divulged on, to any potential buyer that a short-term rental is next door?
I doubt there is an affirmative obligation to disclose that.
Would there be a reason? I'm sorry. Would there be a reason for you to have to disclose it if you have called the police 100 times because of this house? Is that considered a nuisance? Is there a reason why you would have to disclose that?
We deal with these disclosure issues a lot, actually, and the standard is any known material defect of your property you have to disclose to a buyer if you're going to sell your property. Okay, so that's the standard. Now, a lot of people do sell their properties because they can't stand their neighbors, and maybe their neighbors are monsters, and maybe their neighbors have done all kinds of egregious things. You're not required to report anything like that in your neighbor, going on next door. That's not something that typically, I guess I could imagine some scenario that would become, something, and maybe if you're having a boundary wall dispute with your neighbor or something that would have so much to do with your property that you need to disclose it because it is material. But how you feel about your neighbors or what's going on with your neighbors is not a known material defect of your property that needs to be disclosed in that context.
Now, you obviously don't want to lie. If a potential buyer says, hey, are there any short-term rentals close by? Are you aware of any? And if you are aware of a short-term rental close by, you can't say no.
Right. Okay. Well, and when you mentioned about like a common wall issue, I do know that we do have a resident who has a short-term rental next door to her, and they have damaged the block wall in between. And she called the city or whatever. They came and they tried to fix it, and then immediately it got, wrecked again. Regarding, it had to do with some umbrellas or something that were constantly banging against the wall. The city isn't really doing anything. So is that something that you could take up? I mean, but you'd have to file a civil complaint against the short-term rental owner?
Yeah, I mean, like most of these things, like most disputes, I would always say that the first attempt should be to negotiate a resolution. You contact the STR owner and say, hey, the property's wall is, more likely to get somewhere with what's the old saying, with honey rather than vinegar.
Right.
Try that approach first. I'm assuming, we're operating under the assumption that you've already done that and that's failed. That's gotten you nowhere. What are you left with? Yeah, I mean, your statement is right. You could bring a civil lawsuit for property damage. You could sue the STR owner and get a judgment against them, ordering them to repair the wall or pay you money so you can repair the wall, to the extent it's damaged. those are all sorts of things that you'd want to talk to a lawyer about, because you want to always be looking at the costs and the benefits. If it's a $10 worth of damage to the block wall, you want to think long and hard before you file a lawsuit.
Yeah, no, and I know this is much larger than $10, but I guess that brings up another point. Is there have been several people that have tried to sell their homes just to get away from these short-term rentals, and they can't, because then people know that there are short-term rentals next door, and so families don't want to buy the home. Investors like it's saturated, they can't get out, they can't leave. Is there any help, anything for those people that are basically stuck there?
And sometimes there are facts in the CC&Rs for an HOA you can look at, and there are certain remedies, but without more, that happens a lot. It happens a lot where there are short-term rentals next door, or halfway houses next door, or sex offenders next door, or any number of things. And typically, without more, that's not something, you can say, hey, you reduced my property value, or you kept me from being able to sell my property because of what's going on next door. That's not something that we've ever come across as a successful claim or cause of action.
Yeah, I think the answer there is probably going to be a disappointing one. I'm not aware of a remedy.
Okay. All right. Well, all right. That's probably not going to help. I mean, and I know that some of the city, well, I guess as far as some of the common wall damage, somebody was just remarking on here that, it's supposed to be the responsibility of both property owners. But if you know that the damage has been done by one person, or you have it, I guess, yeah, I'd have to figure that out. Yeah, it's unfortunate as far as the sales go, but yeah, and you're right, as far as the sex offenders, and all that stuff, halfway houses.
I mean, people do lots of things that may dissuade a potential buyer. My neighbor next door had big, beautiful trees, and he chopped them all down. It looks like a
Right.
a desert. All of a sudden, a buyer says, this neighborhood doesn't look like I'd like it to look, and so I'm not interested anymore. So
yeah, no, I get it. One of the other things that I wanted to hit on here are, you'd mentioned HOAs. We have had a lot of questions about HOAs, both single family homes and condominiums. But there was the Arizona Supreme Court made their decision, I believe it was last year. What was it? Calway versus Calabria Ranch.
Yep.
Which, correct me if I'm wrong, but I believe it basically came down to the fact that if there wasn't already a reference to not allowing short-term rentals in your CC&Rs, you couldn't add it after the fact. Is that basically what happened here?
I don't think the amendments at issue necessarily dealt with short-term rentals, but I think there were 6 lots in this little tiny HOA, just 6 lots, or maybe there were just 5 lots. And one of the 5 had, was bigger than the others, so he had 2 votes. So there were only 6 total votes. And yeah, I mean, the 4 of the 6 votes were to amend the CC&Rs to implement further limitations. You couldn't have more than this number of buildings. You couldn't have more than this number of livestock. And, the owner of the large parcel, who had the 2 votes, everybody else but him voted to amend the CC&Rs, and he sued and he won. And the Supreme Court said, yeah, the original declaration didn't give this guy sufficient notice that these limitations might be implemented in the future. And so you can't amend the CC&Rs to add these limitations now, because he didn't have enough notice from the original declaration. And you can, there are people that think that was a great decision. There are people that think that was a terrible decision. It's kind of hard to, I mean, if you have a majority, here they had, I guess you could call it a supermajority, 66% of the votes. in favor of these amendments. And, I think there are scenarios where the original declaration, there's no way to foresee all the amendments you might want to make in the future. So, say what you want about the decision, but that is the law. And I think as it applies here, if your question is, could we amend, the documents to prohibit STRs, might be tough. Might be tough after this.
Yeah, it almost seems as if now you'd have to have 100%.
If you had 100%, you could do it.
Yeah.
But short of 100%, I'm not saying that you might have specific interesting facts that give you a basis for making a creative argument here that the court would buy, but it'd be definitely an uphill battle in light of Callaway.
Right. And then I'm assuming, so if you're not, like where I live, I'm not in an HOA. And we have deed restrictions that were formed back in like 1970. And it does mention short-term rentals, it mentions boarding houses, that type of thing. But if, in the case of if you're in a non-HOA neighborhood and you wanted to create something, I'm assuming, would you have to have had deed restrictions? I mean, I don't know how you would do, if you don't have deed restrictions, if you don't know what your area is, you can't just pick and choose homes. I mean, you can't. So I don't even know how that would work with deed restrictions, because, and I know people have done it. And I believe it is pretty costly to do it. But it's not like there's an HOA, there's not some sort of commission that's going to stop a short-term rental. You as the neighbor would be responsible for trying to stop an STR from moving in. And I mean, even if they do, then you're responsible for taking them to court. Is that correct? I mean, it basically falls on the neighbors.
Yeah.
Let me respond.
Go ahead.
I'll respond just to the idea of how an HOA is formed first, and maybe get to your question. Very difficult to establish an association after the fact when there's already different players involved. Usually an association is formed when there's a single owner developing a large parcel. And so they say, hey, we want to develop a neighborhood that has these values, these rules. They'll put it in place since there's only one owner, and then everyone who buys into it afterwards is aware of those rules, and that's fair game to exclude things like what you're talking about. If you've already got a dozen different neighbors or more in a community, you can imagine how difficult it might be to get everyone on the same page about how to restrict their property. But it's doable, and it's possible, I guess I should say. If you do have a street where you all take your neighborhood very seriously and you want to implement deed restrictions, there's nothing to keep like-minded neighbors from implementing those types of restrictions, as many as are willing to do that. You can't rope in those in a community that are not willing. It might end up being a patchwork, but that may be one solution that people can look at who want to have those types of restrictions that are enforceable. Once you have an enforceable deed restriction or some other type of regulation through an association, then you can enforce those things. I mean, a short-term rental is not going to be allowed to move in if there are valid deed restrictions that predate, someone trying to get in with a short-term rental.
Okay. So, well, and I saw somebody just ask, can you add a deed restriction to your home? If you're selling it, can you add some sort of deed restriction to your property that would stop the property from selling to a short or becoming a short-term rental?
Sure. Yeah, you can have, there's all types of creative deed restrictions that you can put on your own property.
Nice. Okay.
And some are no longer allowed. Certain deed restrictions historically, asking for segregation or something crazy like that are old-fashioned, outdated, and unenforceable. But within reason, you can put deed restrictions on your own property. And if you've got neighbors who feel the same way, you might have a little group or an enclave where, hey, we're on this street or within this area, we're all deciding that we don't like short-term rentals, and we're going to put that into a deed restriction that affects all of our properties. So whoever comes next after a property is sold, we're going to maintain what we have here. That's totally doable.
Wow. And yeah, that actually sounds like a better plan, frankly.
Yeah, you just got to persuade people. That becomes, the legal part of it is easy. The persuading your neighbors to say, hey, let's rein this in. Let's make this neighborhood protected against, say, short-term rentals or halfway houses or whatever it is that's enforceable within the context of a deed restriction. Then the actual legal document that we can prepare and record against those properties isn't too bad at all.
Yeah. Okay. That's good. Thank you, Bert. That's actually some good news. I'm happy to hear that.
There's an option.
So one of the other things that we've been getting from condo owners especially is if their CC&Rs, well, some of them, clearly say that you're not allowed to have short-term rentals, but they're still in operation. But if you don't have an actual, like a condominium association, or the condo is the development is being run by a property management company or someone that is not willing to, stop the behaviors, or stop the owner, is there recourse for the residents that live full-time in the condo development to stop short-term rentals if it's in their CC&Rs that they can't operate, if they don't have help from their property management company?
I'll take that one too, unless Tony, you want to express your thought. A lot of times that's the case within an association with the board or whatever enforcement mechanism that's there with the association. They're just not real excited about enforcing one thing or another, say the prohibition on short-term rentals. And if you can't get, within an association, the political willpower to enforce those things, you have still your private right of action. You've got privity of contract with your neighbors through those CC&Rs, and you can enforce them independently, regardless of whether the association chooses to do that. Now, you can't do that on the association's dime. Obviously, you can bring your own cause of action on your own dime to, say, prevent a neighbor from having a short-term rental there, if that's what the CC&Rs or a deed restriction says.
Okay.
You don't have to wait for the association to take action, or if they're just not effective with the actions they are taking, you can take things into your own hands. The only downside is now you're spending your own money. You're not spending the association's resources to pursue that.
Right. All right. And if they are allowed, if short-term rentals are allowed in a condominium development, or even, I guess, a subdivision, and the visitors damage, some of the common area, amenities, how is that? Who's at fault there?
Yeah, I'd say the owner, and then the owner would be turning around looking at his guests saying, hey, you did some damage to the common areas. There it may be more difficult for another owner in the association to bring that action because they don't own the common areas. It's the association that has standing there to pursue those types of claims for damage of common areas. But if it's a breach of the CC&Rs in the first place to have a short-term rental, you still again have that option as an owner within the association with privity of contract with that other owner, because you're all subject to the same set of CC&Rs to bring an enforcement action saying, hey, we've got a contractual obligation. We're all a party to these CC&Rs. We're going to enforce this against you. Look, you've done this against the CC&Rs, allowing, operating a short-term rental. Now it's resulted in damages. So not only are we going to try to stop you from operating a short-term rental, but we're going to now try to measure damages for you doing that. Now, those damages are probably to be had by the association, right? There's damages to the association if it's the common areas, but you've got that privity of contract, which could be helpful if you don't mind taking on that fight.
Okay. All right. And real quick before I move on to the next big question, I figure I will take Mayor Jablow's question. Mayor Jablow, are you still on? Are you still on the talk? I don't know if he's still on here. He was asking about the real estate association that's been going after. Have you guys heard anything about this, about the real estate association, or had any dealings with them as far as them fighting any regulations to short-term rentals?
I'm not sure what he was referencing specifically. I think he mentioned that there's a realtors association that generally is not in favor of any governmental action limiting or prohibiting short-term rentals. And you can see the their view, I guess. Realtors are interested in moving properties. They're
Mhm.
not interested in restrictions and things that could affect their interest. So he made that comment. I don't know what specific question he had about that type of lobby or that type of that group of interests. It does oftentimes just become a political issue. Arizona takes property rights very seriously. That's why this group exists, right? And there's people on the other side of that coin, right, who takes their right to operate a short-term rental very seriously too. And there are realtors who will advocate for that very, very strongly because it affects their interests as realtors. So that is what you're up against if you want to limit the use of a property as a short-term rental. You're up against someone else who says, hey, my property rights are important too.
Mhm.
And it becomes a political question, very difficult to resolve for a municipality. I could see the mayor's trouble there. He's fielding complaints probably on both sides of that and wondering what can we do. You've got to walk that line politically. That's difficult to do.
It absolutely is. And it brings up the point. Yeah, when you're talking about property rights, that's the biggest argument that was being made for short-term rentals back when we were trying to get the first bill passed to amend 1350. I think it was 2017 or 2018. And the Goldwater Institute was down there, fighting for property rights, and that short-term rentals should be treated no different than long-term rentals. But it comes back to the question that we get asked the most is, what about a class action lawsuit? And I know, Tony, you and I spoke about this briefly on the phone, but can residents get together and sue the state? But essentially, from what you had said to me, that's a policy issue, and that's something that we need to try and change at the state legislature, which we have been trying for many years with no luck so far. Is there a way that you could see residents filing a class action lawsuit, whether it's against a municipality, whether it's against the rental platforms, how do you see that ever being, foreseeable that would work?
You'd be up against several obstacles in a class action. A class action, to sort of a little background, but class action does not give you a claim. It allows you to assert a claim that you have in a kind of a unique way, but it doesn't give you a cause of action. You have to have a claim in the first instance before you can even start talking about a class action. So a class action just means it's a lawsuit with a big group of plaintiffs, not just one or two, but a big class of plaintiffs. You have to prove that that class, that group, is so numerous that you cannot join each individual plaintiff. That's just not practicable. You also have to establish that the questions of law and fact are common to all members in the class. So, if you got 10,000 Arizona residents to band together and to sue, STR operators in general, it would never work, because there's, each STR is subject to maybe a different set of HOA rules, a different set of CC&Rs, and a completely different set of facts. This guy has an STR that constantly has guests that are trespassing. This one has an STR that people are, partying late. So a class action wouldn't work in that scenario, because you just couldn't get a group large enough that all had the exact same claims.
Mm-hmm.
Now, if you're talking about suing the state, I guess you have to first go back to, well, what is our claim against the state? What basis do we have for suing the state, if it's or the city or whatever the government entity is? If you're trying to sue the city, for example, for failure to enforce an ordinance,
Mm-hmm.
again, that's going to be an uphill battle for another reason, and that is, I don't think a lawsuit like that, whether class action or otherwise, is likely to win. A city it has all these ordinances, and it has discretion probably to pursue violations of these ordinances, but it has limited resources. It's not ever going to be able to prosecute every violation of every ordinance. And so I don't, the fact that it didn't follow up and fully enforce this ordinance, I don't think you'd have a valid claim against the city for that decision not to enforce that ordinance.
Mm-hmm.
I think your better remedy, is a nuisance claim, for example, against the neighboring STR, and that doesn't bring about global, large-scale resolution, which I know is one of the goals of the alliance. So, if we're looking for big, large-scale resolution, I think we've talked about it. The political process, as unsatisfying as that might be, or as although maybe the track record hasn't been great, I do think that's your best bet if you want to get STRs, banned in general, or limitations to apply across the board all over the state.
Well, I mean, I guess, when you were talking at the beginning about property rights, there are two sides to that. I mean, would you be able to sue the state for your loss of property rights, that the state took that away for money? I mean, to allow people to make money off their, I mean, is there any legal precedence as far as property rights go? I mean, I've often heard it said that your property rights end at your property line. So is that in fact, is there a legal basis for that? Because if so, then it wouldn't be very difficult for us to prove that what's happening on a short-term rentals property is going into, long past their property lines. I mean, property rights, that's a tough one, but could you sue on the other side of that?
Well, go ahead, Bert.
Right. Well, when it comes to the government, and whether it be a municipality, the county, the state, any government entity that takes your property rights, I mean, they can't do that without due process, right? We hear about eminent domain, right? That's the common one, a taking. There is such a thing as a regulatory taking as well, which isn't as common or as heard of, but where, let's say, the government makes your neighborhood a nature preserve, or something like that, and makes it completely worthless. That's a regulatory taking. They've got to compensate you for that. They can't just take away your property rights in that respect. So to extend that theory of a taking, or even a regulatory taking, to a government action, it may be a big jump. But to answer your question, if the government takes your property, or a right in your property, a taking analysis could apply. And if it's a regulatory taking, that's something you could take a close look at. I haven't seen that work or even tried in the context of a short-term rental ordinance or anything like that, but that would be the mechanism, at least.
So neither of you have seen any property rights court cases or anything like that?
Now, I think this group would be the first to know about it and leading the charge if there were such a thing, right? We like to think creatively as lawyers, but oftentimes we'll bring our clients back down to earth and say, look, there are limitations in what we can do judicially or what we can ask for. We want to be aware of options and even be creative in getting results that are really favorable. But I haven't seen anybody, I can't think of a great way to go after the government for saying, hey, the way you're regulating short-term rentals has affected my property rights and I want a remedy.
Well, and you haven't seen that phrase about property rights ending at the property line. Do you know if there's a legal basis for that?
Oh, it sounds like a platitude. I don't know. It's a hasty generalization.
I don't know.
Yeah, I mean, the fact is, things that can happen outside your property line can affect your property, and legal options are often available. Now we're looking at, what is the effect of short-term rentals and what can we do there? You've got lobby rights, you've got, the opportunity to get involved with a common set of restrictive covenants. Outside of those mechanisms, it's hard to it's hard to say, hey, yeah, here's this magic way we can go after the government or some other private actor in a way that will feel satisfying.
Okay. And one, I know we're coming up on our hour now, but I do have one final question that has to do more with you guys as far as how it works with attorneys. One of our supporters, a resident here who was served a harassment injunction, had a very difficult time trying to find an attorney because the person that had filed the injunction had at one point like hired a bunch of attorneys from all around the valley, and she said they wouldn't even talk to her because they had already had a conversation with that particular short-term rental owner. Is that correct? Or, I mean, is that a strategy that some of them use as far as, keeping their neighbors from trying to get legal help? Is that legitimate?
There's such a thing as a conflict of interest. And so if I've heard from, say, a short-term rental operator about the specific facts of a case, and then I get a call from the other side of that case, I could have a conflict there in talking to that person.
You have already, I mean, I could totally see it, obviously, if you have taken on that person. I mean, if you had like a 30-second call, or you said, I'm too busy, I can't take this case, or whatever, and hung up. I mean,
well,
like,
yeah, I would interpret that. First of all, there's a lot of lawyers,
right?
And an STR owner, that's not a very efficient strategy to go try to disqualify every lawyer in town from talking to you by, I guess, giving them confidential information about your case. I don't, that's just not I don't think that's part of a concerted effort to preclude someone from getting legal counsel. I think what's happening there probably is that the lawyers that are being approached aren't interested in taking the case.
Okay.
Like I said, there's a lot of lawyers, and so I don't know how big the group of lawyers is that the resident approached, but you can find a lawyer. You should be able to find a lawyer, unless you have a case that nobody wants to engage with you on.
Okay. And so everybody on here should know too that if they have an issue that they might still be questioning after listening to this, or we didn't hit on that specific issue, they can always reach out. It's a free first consultation, correct? I mean, it's how does that work for you guys?
Well, we'd love to, receive any and all follow-up questions that folks have. I know there's lots of questions that people have that are very specific, and there's no way to touch on everyone's questions in an hour today. We're talking generally, and so if you'd like to talk more about your specific case, absolutely. Orangewood Law Group is the name of our firm, and feel free to contact. We can talk about whether an engagement would make sense. We can talk about what an engagement would look like if it's something you'd like to pursue. Okay. Absolutely.
Yes. And so, yeah, I want to thank Tony and Bert. They are the principal partners at Orangewood Law Group in Mesa. So you can find them at orangewoodlaw.com, correct?
That's right.
Website. So yes, please, thank you guys for helping out Amanda and Celso. Yeah, great job. But thank you so much for taking an hour of your weekend to answer these questions for us. I really, really appreciate it.
Thank you, Kate. I appreciate you being invited. Thank you. Thanks to everyone.
Yeah. Thank you, guys.
It's our pleasure. Thank you.
Thanks. Have a good weekend.
You too.
All right. Take care.